All right, aspiring barristers, listen up. For your bar exams and definitely for your future at the bar, there are some tools you just have to have in your toolkit. Today, we're going to master a really critical one, Section 23 of the Federal Court of Australia Act. Trust me, this is the court's powerhouse provision, and knowing how to use it is absolutely non-negotiable.
So here's the game plan. We're going to kick things off with the foundation of Section 23 itself, and then we'll walk through its key applications. Everything from managing those messy parallel proceedings right through to how it's used even after a judgment seems final.
So first up, the Section 23 toolkit itself. Let's get our heads around the very foundation of the court's power.
I want you to think about it like this. Litigation can be, chaotic, right? You've got multiple parties, really complex issues, all sorts of tactical games being played. So, in the middle of all that mess, how does the court actually cut through the noise to get to a just result?
Well, the answer is Section 23. The best way to think of it is as the court's Swiss Army knife. It's this broad, incidental power that lets the court make pretty much any order it needs to do justice and to control its own process. Now, it's not a blank check, but it is the foundational power that everything else is built on.
Okay, let's grab the first tool from the kit. Controlling parallel proceedings. This is something you are absolutely going to face. Scenarios where the exact same fight is happening in more than one court at the same time.
So when you've got a case running in both a state court and the federal court, Section 23 gives the federal court three clear options to stop things from descending into chaos. First, it can stay or pause its own proceedings. Second, it can enjoin, that is literally stop, the parties from continuing in the state court. Or third, it can just transfer its own case over to the state court.
So, how does the court decide which path to take? Well, the guiding light here comes from the High Court in Stack versus Coast Securities. The number one paramount consideration is what's best for the people involved, the litigants. And the court that can solve the entire puzzle, not just a few pieces, has a massive advantage. That's the logic you need to have in your head. Now, for your bar exams, get your pens out or just burn this into your memory. The key reference you need is paragraph 32,955.80 of the commentary. That's where you'll find all the detail on these powers. Let me say it again. That's 32,955.80.
And it's a very similar story when you're dealing with foreign proceedings. If you look at paragraph 32,955.85, you'll see the federal court can either stay its own case here in Australia, or, if it's the right thing to do, stop the case from continuing overseas.
Let's move on to our next tool. This one is about the court's power to protect the very integrity of the judicial process itself. It does this by preventing what we call an abuse of process. This is absolutely fundamental.
At its core, and you'll find this discussed in paragraph 32,955.120, an abuse of process is basically any time someone uses the court's procedures in a way that's unjustifiable, oppressive, or that just makes the whole system look bad. It is a power of last resort, but boy, is it a vital one.
So, what does this actually look like in the real world? Well, the classic examples are things like trying to have a second bite of the cherry by relitigating something that's already been decided, or bringing a case that is, quote, foredoomed to fail. It just has no real chance of success. Or even running a parallel case just to annoy and harass the other side.
Okay, for your exams, this is a huge distinction to get right. The idea of abuse of process is broad, it's flexible, and it's all about what the interests of justice demand. It's different from those stricter, more black-and-white rules like res judica or estoppel, which are about specific claims that have already been legally stamped done. Abuse of process is like a safety net that can catch situations that those stricter rules might miss. Next up, and this one is aimed squarely at you as future counsel, you absolutely have to know the court's direct powers over the main players in any courtroom drama, the parties themselves, and just as important, us, their lawyers.
Paragraph 32,950.90 is your go-to reference here, and it gives the court some serious muscle to regulate what we do. For example, the court can literally stop a lawyer from acting against a former client to stop confidential info from being misused. It can slap a personal costs order on a lawyer if they've acted improperly, and it can even order you to hand back a client's files. These are not powers to be taken lightly.
We tend to think that a final judgment means case closed, game over. But under Section 23, the court keeps a few tools handy to make sure justice is still being done even after those final orders have been made. Finality isn't always as final as it seems. So the court has a few key post-judgment powers.
Some are about fine-tuning things, like releasing a party from an undertaking they gave, that's under paragraph 32,955.75, because circumstances have changed, or using liberty to apply to sort out the nuts and bolts of making an order work. But others are way more drastic, like setting aside an order completely because of fraud, that's 32,955.15, or in really rare cases, reopening the whole argument under 32,955.16. So after looking at all these specific tools in the toolkit, let's just pull back for a moment and make sure we grasp the big idea, the overarching principle that holds all of this together. What's the final word on all this power?
At the end of the day, Section 23 is so much more than just a list of rules. It is the engine that allows the court to do its job. And what is that job? To make sure its orders actually work and that its processes are used to get to a just, quick, and cheap resolution of real-world problems.
In this quote, it just perfectly captures the single unifying theme here. Now, yeah, it comes from the section on reopening an argument, but honestly, it applies across the board. The ultimate test, the question you always have to ask for any Section 23 power is simple. What do the interests of justice require right now?
So, we'll leave you with this question to chew on for your exams and for your career. We know Section 23 is this incredibly powerful and flexible Swiss Army knife, but clients, they need certainty. As a barrister, your job is going to be to stand right in the middle of that tension. And understanding the principles we've covered today, well, that's your first and most important step. Good luck.